the legal definition of a trust is that it's a legal arrangement where a person, who we are going to call a settlor, transfers legal ownership of their assets to a trustee or trustees, more than one, to manage for the benefit of beneficiaries. So the key things here is that there's a settlor, there's a trustee or trustees, there's a beneficiary, and of course there's a trust deed that forms that relationship. And then of course there's somebody else there called an enforcer, and I'll let you go a bit deeper into each of those tenets. And of course this is trusts are formed under the Trustees Perpetual Succession Act, and then a trust can either be revocable or irrevocable. Revocable meaning you can have the right to terminate the trust, or you can decide that it's irrevocable, meaning it will run for perpetuity. And then one of the key things is that for beneficiaries, they must be identifiable. You must be very clear in your trust deed as to who you define to be a beneficiary. This beneficiary may be alive now or in future, because people can you can create a trust where you say all all the people in your lineage. So they are not in existence now, but they will be. And so long as you're clear, then they qualify as beneficiaries. Then again, in the standard form where to create a contract, because a trust is literally, a trust deed is like a contract, you must have capacity. So again, you must be a person of the age of majority, you must be of sound mind, and you must know what it is that you're doing when you're forming that trust. And then as we go a bit further, we'll also talk about the fact that the law has developed to allow for incorporation of trusts. This means that you separate the trust entity from the trustees. So in the past, trust acted through trustees. So meaning, if you even see any documentation of a trust, it would be saying XYZ trust, AB and CD as trustees of XYZ trust. So that is how they would even sign off their documents. But now we've been allowed to have XYZ trust as an incorporated entity. This means that, one, it has perpetual succession, meaning even if a trustee passes on, or even all the trustees passes on, there's a mechanism for their replacement. And for maybe to compare it, say, with a company, it gives you that perpetual continuity. So maybe that is the analogy I'd take, that you can keep, trustees can keep changing, but the trust remains through all these processes. And then number two, it can sue and be sued. It can own property. So everything that a legal person can do, a trust can do. So I think that is a good base for you to pick up on now the ins.
Yeah. So just to add on what you have said, Bilha, can we first of all agree trust is not for rich people only? A trust can be created by anyone for as long as you have an asset that can be moved into the trust. I know when people think about trust, they think about the estate of Jenga Karume, so they actually think trusts are for rich people. But actually, just see it as another estate planning tool. You can either choose to do a will or you can choose to do a trust. But better yet, if there are people who plan themselves early, a trust will be the correct estate planning tool to actually even begin, because a trust can actually be created when you are alive. A will take place and will take effect after death, but a trust can actually be created when you are alive, and you can actually even be able to monitor how your trust is operating and how your properties will actually be run and managed in the trust while you are alive. So it's actually a more forward-looking estate planning tool, but secondary to that of wills. Not that wills are bad, but it is more forward-looking in that it can actually be created before the death of the settler themselves, who is actually the person who is moving the assets into the trust. Now, when it comes to the operations of a trust, we have various officials who are actually appointed, who are actually in charge of running the trust. Number one, the first and most important person is the settler. The settler is the person who is moving the assets into the trust. Now, you own properties and you want to move, you want to create a family trust. For purposes of hypotheticals, I'm going to use the Njeri family trust. And this is now me, Njeri, creating the trust. Now, for purposes of the trust itself, it is me, Njeri, moving my assets into the Njeri family trust. So I am the settler. Number two, the people I'm going to have to appoint are trustees. Trustees are now my officials or agents. We said in a will, they are executors. When it comes to intestacy, where you have died without a will, there is an administrator. In a trust, there is who we call a trustee. A trustee is the appointed agent who actually runs the trust under the powers that are constituted under the trust. Now, if I appoint my trustees, they are the ones who are going to be in charge of ensuring that the management of the assets that I have moved in the trust go according to how my wishes have been expressed. Now, how does me as a settlor express my wishes in that trust? I create what is called a trust deed. A trust deed is the constitution. Again, the will is what governs the expressions of the testator. In testacy, we said you did not decide, so the law decided for you. Now, in a trust is also giving effect to your wishes through the constitution, which you call the trust deed. In the trust deed, you will say expressly what is it you want to be done with the properties. If you want the properties to be transferred to your children at a later date when they achieve a certain legal age, or how you want the properties basically governed, and how you want the entire trust to run. Once you create this constitution and you put your officials who are the trustees to manage your estate, then we can say now you have created the estate planning tool that is going to determine how your properties and how essentially how your estate will run. Now, because you have put officials and you have appointed officials in that trust, we need to put a watchman to ensure what? That the trust is running accordingly. So you appoint an independent person or even who can be an artificial person, and it can also be a natural person. This is the person we call an enforcer. An enforcer basically is the watchman or a watch person. Their work is to monitor your trust in accordance with the constitution and make sure that the trustees stays in put. Now, I'm sure so many people are afraid of creating trust because after what we saw and the unfortunate event of the estate of Jenga Karume, which were actually to say it is unfortunate that it went that way.
Yeah.
But we can see, because individual trustees had been appointed there, we can see that there were a lot of mismanagement by the trustees. Actually, even the court had to come in and rectify some of the injustices that were coming in.
Yeah.
So, and that is why over time, the enforcer is actually the person who watches. They are the watchman. They are the watch person that actually monitors the operations of the trust to make sure that the trustees do not go outside their powers and actually run down the estate to the point of when there is something to cater for the beneficiaries, there is nothing at the time.
Yeah.
Now it brings us to the beneficiaries, who are actually the people who are benefiting from the trust. You've decided to move your assets into the trust. You've set up your constitution, which is actually what is going to run your trust. You've appointed your officials and you've put your watchman. Now you need to make sure that all your beneficiaries have been put there, because actually this one caters for very many events. If you have a child and that child is disabled, if you have children under the age of 18, if you have someone else who you would like to cater for, you put them there and you actually say how this trust is going to cater for their well-being. Remember, in a trust, you can actually say that I have a child and they are disabled. So the work of the trustees are going to access my bank accounts and make sure that, number one, my disabled child gets therapy. They get to go to school like other children. They get to do other activities, and you're going to actually say in your constitution what the trustees are bound to do and ensure that, or if you have children who are disabled, children under 18, their well-being continues to run. Okay. Now, Bilha, when it comes, now that we have looked at the scenario and the agents that are coming together now to form the Njeri Family Trust.
Yeah.
There are situations whereby you find that when I'm moving the property into the Njeri Family Trust, and I'm asking, what about stamp duty? Am I going to pay any taxes?
Yeah. So of course there are benefits. There are benefits of using the family trust structure. But even before we jump to the benefits, I think we also needed to, you spoke about these things that the trustees can and cannot do. And I think this can also create some level of for us to distinguish between, one, there's a discretionary trust, and this is just for our members to appreciate. You may set specific objects of the trust and say that things must be done exactly like this. So in that case, it's a fixed trust. But if you're giving your trustees some level of discretion to understand the needs, you'll see some people will say that this trust is only to cover education expenses. So then that is a fixed trust because you've set a specific object
purpose.
and trustees cannot do anything beyond that ambit. However, if you want it to be broader, to say, so long as it's for the benefit of my people in my lineage, trustees have discretion or the level of support they may give one person vis-a-vis the other. And then, of course, the last type of a trust there is a blind trust. In this case, the beneficiaries are usually not aware of the existence of the trust. So some people may create a trust that maybe materializes when, say, your child turns 21 years. So they may not know that the trust exists. And then now when they turn 21 years or 25 years or whatever other age, then the trustees reach out and let your child know that, by the way, there's a trust here that has now crystallized. And then you asked an important question, and this was with regard to stamp duty. So there are exemptions for stamp duty when, assuming Jerry had 5 parcels of land, out of these 5, she wants to have 2 parcels that will remain for the benefit of her. Remember, you can also be a beneficiary of her and her beneficiary and other beneficiaries that she has specifically listed in the trust. So those 2 parcels can be transferred, and one applies in terms of procedure. You make an application to the collector of stamp duty and seek an exemption, which is granted because it's allowed in the Act. Then move the asset into the trust entity. While we are saying this, there are also other benefits. So stamp duty is one that comes to mind automatically because naturally, if it's property, if it's real estate that you're transferring, we know that the stamp duty can be a big deterrent for somebody because you're thinking, I need to pay 2 or 4% of the value, yet there's no change of ownership or anything like that. I'm just organizing my affairs. So other benefits, of course, are one, remember the long probate process you've been talking about. So we are talking about estate planning. So the advantage of, as you said, of the trust is that it's formed in your lifetime. You can be a beneficiary. And then, guess what? It will bypass your probate process because it means it's already in existence. Is you have not willed it away. You have not left it to be dealt with under intestacy. It's already a running program on its own. So there will be no long process for the people that you love, that you've put in as your beneficiaries. Then they will continue with life and benefiting from those assets. Then it allows you to do cross-border planning. So if you have assets in other jurisdictions, you can create this trust and it can be the one that's holding those assets on your behalf. Then, of course, it's credit protection, though here there's a rider. So you can put assets that are put in the trust do not belong to Njeri. Remember, I said that a trust has its own persona, a legal persona, very separate and distinct from Jerry. So Njeri Trust, despite sharing a name with you, is a very distinct legal entity from Jerry, the person. So it means that if Njeri is being sued, it's not the trust that's being sued. If you come by hard times and lose your assets, maybe through auction or something like that, these assets in the trust do not form part of your assets. However, the rider here I was highlighting is it should not be that Jerry transferred the property into the trust in order to avoid paying debts, because then, of course, the law will catch up with you because that's a way of trying to evade creditors. So that's another thing. Then, of course, we said you are a beneficiary, so that is an automatic plus. And then there's also the fact tax exemptions we have covered. Then there's protection of assets for generations to come. So maybe you may be thinking that, say, I have children, these children, I want them to benefit, but I also want other generations to benefit from the work I have done and maybe make life just a little easier. So if you're able to do that, you can do that very comfortably using a trust, so long as you're very clear in your wording as to who the beneficiaries are and the objects. Then lastly, of course, there's privacy. So you talked about the unfortunate case of the Njenga Karume Trust. And of course, the unfortunately bad news is the notorious things are the ones that get to the news and you get to see them.
Yes.
However, the positive and the success stories are never told. So the success stories of trusts have been there. I mean, in even our last session, we talked about the Rothschild. There's so many trusts out there, and maybe even within our country that we may not know, but they are there and they are successful. And because they are private, when a person passes on, even for a small trust, not necessarily one of the big families, when they pass on, there's silence. So you assume there's no structure, or you are forgetting that perhaps the silence is because there was a structure that supported a situation where silence can prevail.
It's evidence of a trust gone well.
perhaps. So those are some of the benefits. And then maybe in Jerry, there are things that have maybe court decisions that have come up over time regarding trusts and what can and cannot be done through trusts, so that it's not just a blanket cover that you're saying that you're forming this trust, then it can do anything and everything. So maybe you can tell us about one of the court cases that has been decided relating to trusts.
So now, when it comes to interpretation of the court, when it comes to trust, and as we are saying, is that the jurisprudence that is being created around these estate planning methods is evolving according to the nature and how how life is becoming complicated over time. Now, we have said the whole essence of a trust is for preservation of someone's estate for the benefit of who? The beneficiaries. So if something is for the preservation, then you cannot do anything that is commercial in that trust. What are we saying? We are saying that if, for example, you have property that has rental premises that is bringing in rental income, that is a trading activities for which is subject to other things that are under the income tax in terms of taxation. There's also the Landlord and Tenancy Act, all those kinds of things. Now, to ensure that the estate, that your estate and your trust does not come into conflict with such laws, you need to separate what assets are for preservation and what assets are running commercially. That is not to say that also the trust cannot oversee some of these things. But essentially what that means is that you would have to create a dynamic whereby the trust actually has a way of having a shareholding in some of these companies that actually owns the assets that are having the trading activities, so that now you are able to separate all these other taxes and other obligations that are owed in regard to the commercial activities away from the assets that are preserved. That ensures that also you do not come into conflict with the Kenya Revenue Authority. You also don't come into conflict with the law. And to ensure that dynamic, you come, visit us, visit me, visit Bilha. We will explain to you, we will look at your estate and see whether, according to the assets that you have, whether we will recommend that you create a trust or you create a hybrid or even just create a will. So the idea is whether or not you choose to create a trust is entirely dependent on specific dynamics on a case-to-case basis of your estate. So I think that is it in terms of interpretation of how I've seen the court doing in regard to the issue of the trading activities, and also what you had said about the issue of taxation, curing mischief, people moving assets into the trust to defeat the law. So remember, whether or not you've set up a good estate planning tool is dependent entirely on looking at all factors. So you have to sit down, be honest with yourself. What is this scenario that you are looking at? How complicated are the scenarios that are affecting my estate? Then now talk to a legal counsel to look at the whole of this ambit, to assess your estate accordingly, and to see whether you need one or the other estate planning tool or even a hybrid. Because in the event that you have property that can pass under will and property that can actually move into a trust, we can decide to do a hybrid of both to ensure continuity and running of your estate, or we can decide to do a will for those assets that can easily be bequeathed without so much complication. Yeah. So we would invite you to come to us and actually have us look at your estate as a whole, and we'll advise on which estate planning tool will be applicable.
Thank you,
Now, when you're moving on to we've come to the end of the discussions on trust, and now we are moving on to emerging issues.
Yes.
Now, I'm sure we've been talking about some of them, we've already raised them as we go.
Yeah.
And on developing issues around estate planning, we've said that there is the will and there is the trust, which are the estate planning tools. And when you do not decide for yourself, the law decides for you. Now, there are other things that are cropping up. I'm sure you've heard things about what happens to my social media accounts. If I have digital currencies like cryptocurrencies and digital wallets, what happens to them? So, Bilha, I think you can take us through some of these emerging issues.
Yeah.
We see whether or not they can even pass under will.
Okay. Okay, I think for one, we can start with the digital assets, which of course now, by way of example, your M-Pesa wallet, your money market funds, cryptocurrency, stable coins, digital tokens, and also access to certain websites and domains. And the way the law treats these, they are treated as movable property under the Law of Succession Act. And of course, then the best thing would be to one, there would be, some of them would be inaccessible, because of the security that is put in place to protect these assets. So the thing to do would be, some of these sites have inactive management tools that allow you to say that if, say, this account is not active for X period of time, this and this should happen. So, and also because you can write a will, you literally, perhaps if you have some digital currency somewhere, you can literally put it in your will so that then your loved ones are aware. Because I say there, and one of the things that happens when you do not write a will is that people may not even know you own those assets. So, and this may happen for not both digital and non-digital. I'm sure you keep seeing the Unclaimed Financial Assets Authority making calls for people to check whether things have been returned to them, dividends and all those things. So you protect your hard work by actually writing that will. And then, of course, we've talked about the tools that can be used. People are now looking at hybrid systems, and I think Jerry has spoken to that. Then also, say for insurance, you can, of course, nominate. So you have a pension fund where you're contributing, you have an insurance cover, you can nominate who the beneficiaries are in that instrument. So of course, the thing to do is that perhaps when you started off this policy, you listed, say, your mom or your father as the beneficiary. But then as life changes, Jerry, say, maybe has children. So at the time when you are nominating, you had not taken care of these children because they did not exist. So the thing to do is to make a mental note to actually continuously update your nominations on the different forums, whether it's a pension scheme or insurance cover, SACCO, I think even SACCO benefits. So you can literally just keep it in your mind that this should be done. And then I think we can also talk about we've talked quite a bit about matrimonial property. And again, if you move property into a trust to defeat one, creditors, or to defeat your spouse, knowing that they have an interest, then of course courts are going to review and make the necessary determinations. Then I think the last thing on these trends would be the issue of resealing of grants. So I think we have members who are from the diaspora. So assume Jerry lives in America and Jerry has assets both in Kenya and America. And I think this can be a practical instance. So you have assets that are here in Kenya, you have assets in America, and you choose to write your will because you're domiciled in America, to write your will in America or in the UK or certain, I'm using these examples because the law allows for at least those two jurisdictions for you to be able to come and seal your, once the will has been gone through the probate process in that foreign jurisdiction and there's a grant, you can come and reseal the grant here. So I've used those as examples. So Again, take legal advice, because it's not all countries that are recognized for purposes of resealing of grants. So you need to identify the jurisdiction that you're in. Would the will that you've written there and the grant that's issued there be applicable, be enforceable in Kenya, so to speak? Would it be sealed? So back to Njeri, assets in America, assets in Kenya. She has a will. These assets in Kenya are both movable and immovable. So the law has a distinction. So for immovable property, the law of your domicile will work. But for immovable property, say land, the Kenyan law is what applies. So when Njeri sits down with her counsel or attorney, as they may call them there, to prepare a will in America, they need to be cognizant that, say, if she has a parcel of land in Nairobi, this parcel of land, when it comes to succession, will be assessed through the eyes of the succession law in Kenya. So if this asset is, let's call it matrimonial property, just for purposes of this argument, and your spouse has an interest in it, but in your will, you decide to give it to one of your children. Again, by way of your will, it's within your right. I mean, maybe under American law, there's no issue there. And perhaps because there's a contribution by this spouse, that is why they're getting a beneficial interest. So they are not registered, but they have a beneficial interest. So Njeri writes her will, it's brought to Kenya, but now, wait, this spouse has an interest. And this interest by Kenyan law is recognized. So you'd have a collision between between the two laws. So again, if you own property in several jurisdictions, it's important to take legal advice so that you bring yourself down to, in this jurisdiction, what is the law in relation to my distribution of assets in this jurisdiction? And then in this other jurisdiction where I'm domiciled, what is the law? And then, of course, in Kenya, for you to go through the probate process in Kenya, you have to have been domiciled in Kenya. And even if not permanently, if you are resident for a period of time prior to your death, then that counts. So those are things that just nuances that our members need to keep in mind, so that, again, to take advice and not to do, just say, I've sat and I've written a will and I've decided I have my two witnesses, but then you may create a will that would be impossible to enforce. So so that would be my input there.
Okay, so I think when it comes to resealing of grants, there's usually a set down and laid down procedure by law, whereby you can use when you're resealing grants and when they are being domesticated here in Kenya. Because remember, when you go through probate in a different country and you are now saying that you want the court to accept that grant in this country, then you have to go through a whole process of domestication, which for in the interest of time is a lengthy and complicated process. And we will then engage you to actually engage us to explain some of these procedures and how it goes. Now, remember, when we said when you're choosing your estate planning tool, it is important that you consider what tool works best for you, especially when you're dealing with a complicated issue of different assets in different jurisdiction. Then you have to consider not only the estate planning tool, but what are these costs that actually eat into your estate, such that you do not want to spend unnecessary cost and actually run down your estate and give out unnecessary expenses, for which will actually be paid from the estate itself at a cost when it can actually be planned better. If, for example, now, like what Bilha has said, when Njeri has different properties in different jurisdiction, and in the case of movable property, the court has interpreted it to say, and even the law of succession, that the immovable property is for the law where the property is situated. Now, you might consider it necessary to actually create an estate planning tool in the jurisdiction where these properties are vested. Why I'm saying that is because if you create a will in Kenya for a property, an immovable property in the United States, regardless of whether what I have created in my will here in Kenya complies with the law of United States, essentially what you've done is that you've created a situation whereby it is only the authorized executor of this will in Kenya who can actually go to the United States and to bring into conformity your expressions and your intentions. What does that mean for your estate? You would have to incur the cost for the executor to travel overseas. You'd have to incur all these legal costs because you would need a second legal consultant in the United States to actually show your executor the entire process for probate in the United States. So what we are saying is that you're supposed to consider creating an estate planning tools in the country of jurisdiction where an immovable property is, just to actually smooth over all those issues and to bring into conformity and actually make sure that that money is not eaten out of your estate unnecessarily. So again, you're supposed to consult with legal consultants to look at the entire ambit of your estate. Let's see how it looks. Let's see the recommendation that we can make so that now you are able to actually create better estate planning tools, so that now also you don't overload your estate with so many legal processes to be done that it actually defeats the whole purpose for which you actually created the estate planning tools. So, Bilha, not unless you will have something to add.
No. I think that's it. So now we can, as we draw to a close, we can just perhaps just highlight to our members So now that you know all this, what's the action plan? So maybe I can take us through the first few. One is to take stock of your assets and liabilities, because as I said, one of the reasons why some things get lost is because no one has an idea of where these things are. You may have perhaps purchased, as maybe using an example that we talked about earlier, through a chama. You have shares in a chama and you people own a piece of land somewhere. Your family has no idea. So one, take stock, list your assets and liabilities. Then now, once you have that is always a starting point. Then now you can sit down and draft your will. And if you, in your circumstances, forming a trust is of value, and this is something you can consult. Maybe take advice from a legal practitioner. Then you can also form a trust, because as we said, there is no problem in having a hybrid system. It doesn't have to be either or. And then, of course, then review how you hold your property, because you might be running on assumptions. Jerry told us about joint tenancies and tenancies in common. So perhaps it's time to take stock and say, okay, because I'm a joint tenant, this is what it means. Because I'm a tenant in common, this is what it means. Is it ideal in my circumstances? Should it be revised? And these are things that families can actually talk about and make the necessary changes. And then this also brings us to the next point of having conversations with your family. I know in Africa it's taboo to talk about death. However, I mean, it's as they say, the two things that are sure is taxes and death. So we perhaps need to open up our minds to discuss our estates with our families. And it's not that we are calling upon death, it's that we are preparing them and also arming them. Because you may write a will. Who knows you've written a will? Where is your will? What are your... you may not need to get into the wishes.
Properties.
Exactly.
The titles.
Exactly. So you may, if you've deposited, say, with a bank or deposited with a lawyer, please let your family know. It makes the process easier for them. Then, of course, as you highlighted, during if in instances where parties have separated, spouses have separated, and there's a divorce, there is a requirement, and actually this is just a highlight, that you file a suit for division of matrimonial property within 12 months of conclusion and obtaining a decree nisi, which is the final declaration. So I think those are some of just the top line highlights that I may be able to cover.
But just to add on what you have said, when you've decided on your action plan and you've decided to consider an estate planning method, then it is an important time, especially for the settlers and especially for the testators. It is a time to call yourself to order and actually be honest with yourself. Honesty is a process that really matters, even when you're sitting down with legal counsel, so that all the issues pertaining to your estate are actually taken into account before these estate planning methods are considered. Why I'm saying that is that most of the wills actually fail, even in terms when you're talking about dependents, because the testator decided not to be honest about something. So you come to your lawyer and you actually tell them, I have 4 children, but you have another child with another person that is left out somewhere. What we are trying to do is put your assets in order, and a will is private and it is confidential. And an advocate who is preparing the will is actually bound to the rules of confidentiality and they're bound not to disclose it. So it is your time to be honest with yourself and actually create something effective and something to last your family and not create confusion. Now, it may not sit well with your family if they later find out that you actually had a child out of wedlock, but it will actually avoid dispute in that you have already expressly provided for each and every person who was supposed to be provided for under will. And even when we're talking about asset preservation, when you move assets into the trust and you've actually provided for how this trust is going to be managed, it avoids a situation whereby you have managers somewhere managing a hotel. Your beneficiaries have never known that you own a hotel somewhere. And so in the event of your death, no one knows that you owned a hotel somewhere. And what does this expose you to? You leave your property to be managed by other people, and people may never even ever come to know that actually this property was owned by this person. And that actually takes away from your estate, and it actually prejudices your beneficiaries. So it is good to be honest and also to avoid mischief during the process of estate planning. Do not create an estate planning tool with the aim of defeating a party or two. Because again, we are saying, mkono wa sheria ni mrefu. They will look at these wills, they will look at the intention of the testator. If the testator had ill intention against any of their dependents, then it is one of the reasons why a will fail. And in another scenario, if you're moving assets into the trust to try and defeat, or rather to try and defeat KRA from taxing your properties, again, the law will actually reach into this trust and it will actually affect your estate planning. So it is a good time to call yourself and say, I have decided to create this, to put my affairs in order, because we do not know about tomorrow, but also create an efficient and effective estate planning tool.
We have a couple of questions which my colleague Njeri and I are going to cover. And the first question is a question of, in case of a joint ownership with a spouse, what should be written on the title? And tied to the same question is, and also if the title was a gift, does this still constitute joint ownership? So here, I think there are two issues. The first one is, how do you capture the fact that a property is owned jointly by spouses? So the way we had explained, on the instrument of transfer of the property, you're supposed to actually indicate that A and B own the property as joint tenants. And what happens is that when the title for the property then comes out, it actually expressly states that A and B as joint tenants. So in the event that this is not captured, if you look at your title and it shows A and B as the proprietors, but with no notation that they're joint tenants, then automatically that is presumed by law to be a tenancy in common. So if, as we said, as you take stock, if the intention is to change that, then that can be changed. However, as it reads, it should say expressly. If it's silent, just by mere virtue of being married doesn't make it a joint tenancy. Then the second part is, what if this was a gift? So this, I think, takes us into the issue of matrimonial property. So for instance, spouse A was given the property, say, by their parents. And spouse B was, when the property was being transferred, it was transferred to both of them. So the title comes out in the name of spouse A and B. If it's in that manner, then that is definitely property that's owned jointly. However, if the title is only in one, the party that was gifted their name, then this property is party A's property. However, we go back to our class on how property becomes matrimonial property. So in such a situation, say party A was gifted by their parents, the title is in party A's name. Then party B comes in and says, why don't we develop this property? They bring in monetary contributions and they put up something on this property, or they add value to it or construct on it and make it maybe revenue generating, or even make it a home. In such a case, you will now need to go back to the issue of contribution. And if party B has contributed, then despite it having come into the marriage as a gift to party A, the contribution by party B cannot be ignored. And of course, then that will matter when, if at all, in the event of, say, a divorce and there's a division of matrimonial property, that would definitely be taken into cognition. And then I'll hand over to Njeri.
For the second question, it said in the case of a post-nuptial agreement, is it valid if it is not certified by an advocate? Now, just to clarify, a post-nuptial agreement or even a pre-nuptial agreement is a contract. It is your arrangement between you and your spouse on how property is going to be distributed or even determined between the two of yourselves according to a set down arrangement. A prenuptial, it means that you've entered into this arrangement of how property is to be distributed or on property that is acquired before the marriage was gotten into. A postnuptial agreement is when the marriage has come to an end and the arrangement was not made, so you do what is called a postnuptial agreement. But nevertheless, the two of all the agreements are contracts between yourselves. Now, when it comes to witnessing, most of the postnuptial agreements and the prenuptial agreements, you will most likely have a lawyer witnessing the agreements because most of the time it's usually the advocate who actually drafts these agreements. However, it does not mean that if the advocate themselves does not witness this contract, that the contract is not valid. Remember, the rules for contract is that it is between the two parties, and for as long as there was an intention to create legal and binding decisions between the two of them, then if you call upon any other witness to witness that agreement, it is actually a binding contract. So yes, when you're answering that question, an advocate is not a necessity when it comes to witnessing the will. They may or they may not witness. You can call your own witness to witness it, but it is not a legal requirement and it will not fail for lack of an advocate's stamp or signature.
Thank you, Jerry. I think then the next question was actually asking whether trustees, how much trustees are paid, and is it a sitting fee or is it a percentage of the estate? And here I think it depends, and the answer lies in the instrument that we call the trust deed. The trust deed is a constitution that guides how the trust is run. So if the person forming the trust, the settler, had an intention that trustees should be paid, then he should or she should list it clearly in the trust deed that these trustees are to be paid. You'll find that in a lot of family trusts, because the beneficiaries, the trustees are also the beneficiaries to some extent. In most of those cases, trustees are probably not paid because they're going to be gaining something from the trust in any case. However, if they're professional trustees, if you've hired, say, a lawyer to be your trustee or an accountant to be your trustee, or hired even a commercial entity, the commercial and corporate trustees to be the ones running your trust, for sure, those ones would need to be paid and you'd have to have entered into some form of agreement with them. So in terms of payments, then it's tied to one, does the trust deed allow for it? And number two, if it does allow for it, then it would also address how they are remunerated, or it could even be left to the discretion of the trustees as to how maybe they are given a ceiling or something, some form of structure as to how they should be paid. Then I think tied to this was a question of whether an enforcer should, I think the query was, what does it mean when you say an enforcer can be physical or artificial? I believe here the question was in relation to, is an enforcer a human person or a non-human person, meaning it's a corporate entity? And the answer is yes, it can be either a human person or it can be a corporate entity that serves the work of an enforcer. And I think the question that also came in tied to that was, now that you have this enforcer, can the enforcer also be a beneficiary? And I think I would say that it's not ideal because the enforcer's work is actually to oversee the work of trustees. So you'd already create a conflict of interest because you as a beneficiary, you may want to benefit in a certain way that is not in line with the objects of the trust. So you may have a different agenda from these trustees and it would cause a lot of friction. So when you as a settler, you're forming this structure, try and create it, if at all you choose to have an enforcer, because again, an enforcer is optional.
It's optional, yeah.
Try and if you do choose to have an enforcer, let it be a person who has some level of independence so that you now do not create a clash between the trustees and the beneficiaries due to maybe conflicting interests that may be outside the umbrella of the trust. I think I may have answered that. And then I think you can answer the next question.
Yeah. The next question was, how much will it cost to establish a trust? Who pays to establish it? And is it the creator or the trustees, or when the creator dies? I think that's what the question said.
Yeah.
So now, when it comes to, we're actually covering this under our presentation. It was supposed to be the last part, so I think I can actually present on the last part as I wind up on it. Sorry, I'm trying to get my slides. Okay, here we are. So now, when it comes to the remuneration, or rather what it costs to set up a trust. Now, the size of how complicated the trust is determines the legal fees that are applicable. Now, most of the people who are creating the trust are legal counsel. They may be created by other people, but most of the people who are creating and drawing these trusts are actually the legal counsels. And so the fees that are applicable depend on the size of the estate that we are looking at and the complications that need to be solved. Now, remember, you don't just put assets into the trust, but one of the roles a lawyer is pertinent to is reviewing the list of all your properties and seeing whether all these properties actually can be put into the trust. If there is something to be done, you see, if you're given a property by your father is now deceased, and you want to move this property into the trust, it cannot be moved when it is in the estate of a deceased person. So we have to do an analysis of all these properties and make sure that the properties that are going into the trust are actually proper and actually merited properties, so that we are able to regularize all your estate and now actually set up an estate that is actually sound. So when it comes to legal fees, we did have a margin of our legal fees on where we start from, just for purposes of information. And for purposes of wills, we start from a legal cost of Kenya shillings 50,000. And again, this is just a set down minimum, and it can go higher depending on the size of the estate and the complications, or rather the intricacies we have to go through to make a proper will. And when it comes to custody of wills, when it comes to the custodian, the testator, who is the person who is writing the will, can choose two options. Number one, you can choose to actually keep your will into a particular custody of a person, or even into a safe deposit box at the bank. And this will actually take away from the fees, and you actually incur the fees yourselves when you actually take the will to wherever place you want to keep it, but it has to be in a safe place. However, when you put it in the custody of the advocate who actually drew the will, there are annual maintenance fees for the will that are required, and this we have set down a minimum of Kenya shillings 10,000, again depending on the size of the estate and depending on the magnitude in terms of the maintenance and the updating of the wills that is going to be occurring from time to time. And number three, when it comes to incorporation of the trust, most of the trust, when you are creating the trust, the fees for incorporating the trust, because at that time you are creating the estate planning tools itself. You have not moved anything, and it is usually on the preliminary provisions of it. It's usually paid by the settler themselves, or rather the person creating the trust. Any other administrative fees, once the trust is set up, then the officials who are now the trustees that have been duly constituted under the trust deed are usually responsible for every other administrative fees, including what Bill has talked about, the remuneration of the trustees themselves. I think that's it when it comes to the remuneration. Again, we will look at your estate and we will advise you on fees and the cost implications. We have also put down our details. We are going to be sharing the slides, the ones that we have used for the presentation to you. They contain our details down below. Feel free to reach out to us for more advice on around estate planning. And I think, Bila, you can now close the
session. Yes,
the session for
thank
us.
you, Jerry.
Yes.
I think, as Jerry has said, I think we've had several queries as to where we can be found.
Mm.
Our firm, Wanjiru Kinyanjui Advocates, are at 1 Padmore Place on George Padmore Road. And as Jerry has said, our details are also going to be shared on the presentation. The circle will circulate to all members. Yeah. And we thank you for your time, and also for joining, taking time on a Saturday morning to learn And we are hoping to have many more engagements where we can all benefit. Thank you.
Okay.